Welcome back to the Friday 5 for September 13th. Friday the 13th, September 13th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. On Fridays, we like to take a quick look at 5 questions from the week, usually from prospective clients, sometimes from current clients. Maybe these are questions you've had before, and this will give you a quick answer to those questions. Question number 1 this week, should I put unimproved land into an LLC? So in this situation, we had an out-of-state prospective client who's purchased some land here in Minnesota, and they were considering putting that land into an LLC. And when we're looking at this situation, the first thing I always recommend is that we talk to a mortgage lender to make sure that the mortgage lender will approve it. So in this case, there is no mortgage. The land is owned outright. And so the nice thing is they have that ability to move the land into the LLC whenever they would like. We don't need somebody's approval. But the bigger question is, what is your long-term goal for the land? And does the LLC suit that purpose? In this case, we have a large piece of land that we may subdivide down the road, and each subdivision may actually contain rental properties or businesses on it. And so what you need to consider is, does it make more sense to have that entire land in the LLC, or does it make more sense to eventually partition it and then put each piece of land into an LLC? This is a great example of where it's important to talk to your professionals, work with your accountant, work with your attorney to have a plan for how you're going to handle that land. So there's no real blanket answer of yes or no. Should you put the land into the LLC? It's the old lawyer's answer of it depends. Just make sure your professionals are weighing in so you know the pros and cons of each situation. Question 2 this week, do I have to start a new lawsuit to enforce an order? So in this case, the prospective client had already been to court with a lawsuit. There'd been an order entered requiring the other party to do something. The other party had not actually done it. And in this case, unfortunately, the prospective client no longer has an attorney. They couldn't afford the prior attorney any longer. And so they went to the courthouse and were wondering whether or not they have to file a new lawsuit to enforce that order. Now, normally, and you'll have to check with the local state or federal court where you're located, but normally, if you have an order from a case that's already existing, you don't have to bring a second lawsuit to enforce that order. What you actually do is file back into that lawsuit, even if it's closed. It would be called post-judgment enforcement if there's been a final judgment. But the normal answer is no, you do not have to start a whole new lawsuit. You can use the order. You want to go back to the same judge who issued the order, especially because that judge can look at the case and say, I remember this case. I ordered the defendant to do something. They didn't do it. And so now I need to enforce that order and force them to do it. Question 3 this week, can I serve a subpoena on an out-of-state bank? It's very common these days that banks will allow you to actually serve your subpoenas and document demands on them through online portals or electronic means. So we don't necessarily have to use an out-of-state process server. But in this situation, the bank is actually located in another state, has no presence in the state where the client is. So we have no ability to actually file it and serve it in the state. So we have to go to the state where they're located. Now, the lawsuit is in Minnesota. It's not in the other state. So the next step is what we call domestication, meaning we have to domesticate the subpoena so that the other state's courts sign off on the old subpoena from the original state and then make it a subpoena in the local state. So through domestication, that subpoena then becomes valid, and then the bank will have to answer it. But until the subpoena has been domesticated, the bank's position is they will not answer that subpoena. Question 4 this week, can my trust own out-of-state property? So in this case, we have a client we've worked on estate planning with, and they've inherited property in another state. And the question is, can they put that property into their trust, or do they have to set up a trust in that new state, or what do they have? What options do they have for this? Now, the first thing you can do is look at the state where the property is located. So in this case, it's a state that does not have a transfer on death designation. So if it had transfer on death designation available for a deed, as opposed to putting it into the trust, one option is you could just do a straight transfer on death deed so that it goes directly to somebody. But in this case, they want the property to be put into their trust and distributed according to the terms of their trust. And this is actually one of the primary reasons we recommend you use a trust is when you own out-of-state property, because your local trust can own that other property. And then if something happens to you, the trust can administer the property, distribute it if need be. It can sell it and give it to your children for college expenses, whatever your trust may specify. And question 5 this week, can I still get a will if I'm over the age of 65? This was an interesting question because I'd never seen this online, and I'm not sure if they'd seen it in a blog post or maybe heard about it in a podcast, but the caller was concerned because they were over the age of 65 and thought that they no longer could have a will put in place, that it had to be done before the age of 65 or else they can't have a will. Simple answer, of course, is no. There's no age limit on how old you can be to get a will. Now, if you're under 18, you're not going to get a will because you're not an adult and you can't sign the will. And that's where we work with things like guardians and trustees. However, when you're over the age of 18, anybody can sign a will. You can be 65, you can be 70, you can be 80. What commonly happens is when you get to those older ages, you may actually have a will from your 40s and you want to go back and update it. Maybe now you have grandkids. Maybe you've had weddings in the family. Maybe you have more children. You've been remarried. There can be a variety of life events. And so what we can do is with those later in life wills, we can make sure that we're planning for what life looks like now, not what it looked like 30 years ago when you first did your will, because your wills do not expire. So if you do a will when you're 21 and you live until you're 89 and you never do another will, that 21-year-old will when you were 21 is still valid. Now, it may not be distributing things the way you would like when you're in your 80s versus when you were 21, but technically it is still valid. So that's it. That's our freaky Friday the 13th set of 5 questions this week. If you like this video, you can hit the like or thumbs up button below. You can subscribe for future episodes on YouTube. You can submit a question for future episodes at the link below. You can always go to my website, 𝙁𝙊𝙇𝙇𝙊𝙒, for a legal strategy session and for more information. And wherever you are, I hope you have a safe Friday the 13th.